State of Idaho versus Austin Eric Christensen. Mr. Christensen is present, along with counsel Mr. Browning. The State of Idaho is present, represented by Mr. Harris. Here today for a scheduled sentencing. We're proceeding this matter, Mr. Browning.
Yes, we are, Your Honor.
Stay ready, Mr. Harris.
Yes, Your Honor.
All right, Mr. Christensen, let me review the history of this case. The time of your arraignment on March 15th, 2024, you were informed that information had been filed against you by the State of Idaho charged with the crime of vehicular manslaughter. At that time, you pled not guilty. However, on April 16, 2024, you again appeared in court with your attorney, and pursuant to a plea agreement with your previous plea of not guilty, your plea of guilty as charged to the vehicular manslaughter. The plea agreement in that case is that the state agreed to recommend to retain jurisdiction, but was free to argue the remaining terms of that sentence. Everything else is free to argue. However, the portion of the sentence that was the retained jurisdiction was binding upon the court. And we discussed at that time what that binding portion meant. After I accepted the guilty plea in this matter, I ordered a pre-sentence investigation report be prepared. I have received that report and reviewed it. The copy has also been provided to your attorney. So let me first ask Mr. Christensen, have you had a chance to review that pre-sentence investigation report?
Yes, Your Honor.
Mr. Brown, are there any parts of that report that need to be clarified or corrected?
No, Your Honor. May we remain seated?
Yes, that's fine. Mr. Christensen, do you wish to stand by the plea of guilty you previously entered in this case?
Yes, Your Honor.
There are going to be witnesses on behalf of the defendant.
No, Your Honor.
Any witnesses or victim impact statement on behalf of the state? This can be you, Mr. Neal, or Mr. Harris?
Your Honor, we don't believe that. I just wanted to take a double check here, but our understanding is there would not be anyone from the victim's family to speak today.
All right, would note that Mr. Neal has joined us. Will you be doing the argument, Mr. Neal?
Yes, sir.
All right. No witnesses either?
No.
All right. Then, Mr. Brown, before I announce sentence in this matter, I'll let you argue on your client's behalf.
Thanks, Your Honor. Your Honor, the defense stands here having pled guilty to the crime of felony vehicular manslaughter. This is horrible tragedy to both families. Mr. Christensen and Mr. Flores, the decedent in this case, were the best of friends for basically their entire lives. Their families are very close. Mr. Christensen, of course, feels horrible about what he did, that night. As the two of them had been drinking, and he got behind the wheel and drove the two, lost control of his car. The car skidded off the road, ran into a tree, and his best friend, Isaac Flores, died as a result of that. It's been extremely hard for him to come to grips with what has happened, and to his great surprise, Mr. Flores' family has been very emotionally supportive of him at this time, and our hearts go out to the Flores family. Because of the circumstances of this case and the fact that the defendant has no criminal history and basically no bad habits, no criminal tendencies, no drug issues, nothing, like that. That the parties have decided that the appropriate resolution of this case is to have Mr. Christensen take responsibility for what he's done, plead guilty to felony vehicular manslaughter. And the parties have jointly recommended a sentence of retained jurisdiction, underlying sentence subject to argument of the parties. I leave that to the discretion of the court. Again, this is, I don't know that it's an unusual case, it's just a horrible tragedy. But I think as I understand, the retained jurisdiction program is an opportunity for the defendant to, number one, take responsibility for what he's done by being incarcerated at Cottonwood during a period of the retained jurisdiction, and to demonstrate to the court that he will be a good candidate for probation. I note that all of that is reflected in the pre-sentence investigation report. The defendant has a LSI score of 3, which, to the best of my recollection, is the lowest score I've ever seen on any criminal case that I've been involved in. And that's because the young man's been a great citizen, except for this horrible event in his life. So with that, Your Honor, and I would also indicate that the family of Mr. Flores understands that what the plea agreement is, and they also they have actually not asked for any incarceration at all, but they do support the plea agreement. Thank you.
Thank you, Mr. Browning. Mr. Neal.
Thank you, Your Honor. Your Honor, this is, I guess this is a significant example of how justice is not something that we can approach categorically. I mean, these are bad facts. We have a high BAC. We have, obviously, a death. The BAC in this case came back at 0.214. We have a family that's grieving the loss of a child, and yet, a young man, for them, their child, and yet there is just, in restoring them in their sense of justice, it had nothing to do with retribution. It had nothing to do with some kind of severe punishment to make them feel like justice had been served. In fact, I think that for the most part, during the pendency of the investigation and so forth, there was just a feeling like, better to forgive and forget and all. And they're not here today. And my experience, as the court's familiar with my background, I have been around victims' families for the better part of 40 years. That nobody grieves the same way, and there is no set way to tell somebody how to deal with this kind of a tragedy. And many of the words that Mr. Browning put forward to the court, I think are well taken. In fact, I find very little disagreement with what has been said. In deciding whether to make this charge, to file this charge, even though there was frankly opposition against it by the victim's family, we had to kind of look in a more general way just to the facts of the case. And so, on behalf of the community's interest, then we felt that the charge had to be filed just because of the nature of the facts and the circumstances. What we saw in response to that has also been exemplary. That Mr. Christensen has taken accountability for what has happened and the decisions that were made that led to this kind of a result. So, in a way, we can't ask more of the defendant than the way that he responded to this. And I think in a certain way that holding a defendant accountable for their actions is in a way good for the defendant. When they do pay a price to the community, when they do pay a price for a decision, sometimes that actually helps them deal with what must be an extreme emotional impact from losing a best friend. The feeling that you caused that, of course, I think often brings about, well, retribution is something that I want to feel myself, that I made this decision, and if I pay a price for it, then in some way, maybe that restores me as well as the community. So based on all of these factors, we are recommending a retained jurisdiction. They are unusual. They are somewhat unique. And like I say, in the sense of how there was a response here, it was exemplary. So the court gets to do this all day long, balance those objectives, the calls for justice, that somebody be treated fairly does not necessarily mean equally. And so in coming to this recommendation, I think that we've tried to balance all of the various factors. There must be a deterrent. There must be, the conduct must be addressed. But there's also a great deal of recognizing where the defendant has tried to deal with this, if not in a positive way, at least in a way that the community can be healed, the family can be healed, he can be healed, and we can look at restorative justice. We cannot bring this victim back. We cannot undo the decisions that led to his death. And therefore, that's why this is a felony case. It's a felony conviction. It carries with it a retained jurisdiction that can be both rehabilitative, but also has that element of punishment to it. So we do think the factors of criminal justice have been addressed here by the parties. We do think it's appropriate to have that outcome, where in other cases the outcome we would be arguing for something much more severe. Our recommendation for underlying then is for 3 years fixed, 9 years indeterminate. We anticipate, given the LSI, that would be unnecessary for that to be imposed, because we do expect that Mr. Christensen is going to move forward in a positive way and take advantage of those lessons that can be learned through the programs up in the retained jurisdiction program. So we don't expect to see Mr. Christensen back before the court except for the review at the end of the rider program. We do expect him to now contribute to the community and to face decisions with a different perspective. We expect that that's going to make him a better person, and ultimately our expectation is that the community is going to be benefited by those things he chooses to do in the future instead of endangered. So that's the reason for our recommendations, Judge, and we think that they will serve the purposes. It is something that we're not approaching categorically, and but we think that it is just and fair, and that's the reason for the recommendations that we come to.
Thank you, Mr. Neal. For now, sentenced in this matter, Mr. Christensen, I'll give you the chance to address the court. You are not required to say anything, nor do I hold it against you in any way if you choose not to. However, if you do wish to address the court, I'll give you that chance. What would you like to say, sir?
Yeah, I would.
Go ahead.
I just want to say that Isaac was an amazing person. He had a positive impact on everybody that he was around. Everybody loved him. Everybody wanted to be his friend. He was definitely a positive member of the community, and I think it's an absolute tragedy that so many people are going to miss out on that now. I understand that drinking and driving is a choice. It's a choice that I made that night that haunts me every single day. He has an amazing family. They're some of the best people that I have met. Genuinely, they held no judgment against me. They didn't even say that there was a need for an apology because they weren't upset at me. And I'm just happy now to be able to be in a position where I can satisfy the community and move forward. Thank you, Your Honor.
Are you satisfied with the representation of your attorney?
Yes, Your Honor.
Mr. Browning, is there any legal reason why I should not sentence the defendant today?
No, Your Honor.
Mr. Christensen, then based upon your plea of guilty, it is a judgment of this court that you are guilty of the crime of felony vehicular manslaughter. I have carefully reviewed the record in this matter. I have listened to the argument of your attorney, as well as the argument of the state, listened to your statement, and have considered the objectives of criminal sentencing adopted by the Idaho Supreme Court. Those are the protection of society, deterrence, rehabilitation, and punishment. I've also reviewed the number of letters that were attached to the pre-sentence investigation report, and have considered the criteria in Idaho Code 1925-21 relative to the question of whether I should place you on probation or confine you to prison. These cases are difficult. I have sat in Mr. Browning's shoes as a defense attorney and represented people who have committed a crime like this, killed somebody while they were driving under the influence. I've sat in Mr. Neal's shoes as a prosecutor and prosecuted people for doing that. And frankly, these are the hardest cases that I think we deal with as a court system. Because in this case, Mr. Christensen committed a horrible crime. Mr. Flores has passed away because of your actions and what happened. However, you're not a bad person. I'm going to talk about the case in just a few minutes, but I actually wrote down what Mr. Browning said. He said it's not an unusual case. It's a sad case. And frankly, it's horrible, but it's not an unusual case. I have unfortunately had to do this more times than I want to do, where somebody is killed. In this case, it was the passenger and your friend. Other times, complete strangers are killed by complete strangers for no reason other than somebody decides to drink and drive. So I think that what the state's done with bringing the charge of protection of society is important. I think that it is something that our society needs to deal with. And in this case, there is a plea agreement where this court, I am bound to accept it, meaning that I can either reject the plea agreement, in this case goes to trial, or I can accept the recommendation of the parties and place you on a retained jurisdiction. I want to talk about the actual facts of this case. I think it's important that we put on the record exactly what happened. I'm referring to page 1 of the pre-sentence investigation report. It says that Officer Hendrian was called to investigate a single vehicle crash on the Snake River Parkway. When he arrived at the scene, the area was closed off. There was a silver truck in the grass with tree debris in the road. The front passenger, identified as Isaac Flores, died at the scene due to injuries sustained in the crash. And the driver had been transported to Eastern Idaho Regional Medical Center. Officer Hendrian did the initial walkthrough. He observed the speedometer of the truck was stuck at 55 miles an hour. There were indications that alcohol was a factor. There were cans of Bud Light on the ground in the vehicle. Some appeared to be open and empty. During the ensuing investigation, it was determined that the vehicle traveled northbound on the Snake River Parkway, left its lane of travel, driving on the raised center divider for about 183 feet before striking a tree. There was no indication the driver had attempted to slow the vehicle. After hitting the tree, the vehicle traveled another 48 feet before returning back to that northbound lane. The impact caused the tires to become separated from the bead of the rim, with the driver's side wheels gouging into the road surface, causing the vehicle to spin clockwise around its center of gravity. Before it could completely spin, it hit the hard frozen ice and snow that had been plowed into the east side of the road, impacting on the front driver's side. This impact sent the vehicle into the other lane of travel, and momentum caused it to leave the ground and roll in midair. While in the air, the vehicle hit another tree. The vehicle made at least one rotation, landing on the passenger side of the vehicle, on top of a fire hydrant. Skip the next sentence. It says the vehicle then went airborne and continued to roll, coming off of the fire hydrant, coming to rest facing east about 43 feet from the hydrant. That's a horrible scene. The clock, the speedometer was stuck at 55 miles an hour. Clearly there was ice and snow that had sidewalks on both sides of the road. In this case, sadly, Mr. Flores passed away. We're just lucky there's not more. We're lucky there are not kids walking along the road. We're lucky that there was other drivers that were not struck. And when we talk about protection of society, this is exactly what we're talking about. I mean, when I read through this, absent the plea agreement and the other mitigation factors, you wouldn't be doing it right. You'd be in prison. You put the community at risk, you put yourself at risk, and you cause the death, cause the fatality of who I recognize and acknowledge as a friend of yours. I want to say just one thing for the family of the victim. I understand their loss. Well, I can't understand their loss. I've dealt with other families who have gone through similar loss and know and acknowledge the pain. And I do understand how people deal with pain differently. And sadly, this court, nor the state, nor anything we can do, and Mr. Neal referred to this, we can't undo the facts of this case. We can't change what happened, and nobody can. And I'm sorry that they're going through this. I'm sorry for their pain. And like I said, I hate these cases because good people suffer, both those who pass away and frankly people that commit this crime. And what you said in your statement on page 2, and you've said it again today, drinking and driving is a choice. It's a choice that people make that kills people. You acknowledge you made a horrible choice early that morning, and you regret it every day, and I believe that. And I think that is appropriate because there's nothing that can be done to take away the pain of the victim's family or to bring the victim back. I do think you've expressed remorse. I do think you have good family support. I do think that you regret what happened. You're employed in a family business. You have no prior criminal history. This is the only charge that you have. But that's still, all of that still doesn't take away from the fact that the victim has passed away in this case. I do want to acknowledge like I said, the family support. I want to acknowledge the good things you have going on. But once again, that doesn't take away from the facts. I will indicate that the court will follow the plea agreement in this case. I believe that these cases are individual, but I do think that it's proper that this charge be brought, and I believe that it's proper that punishment be paid. Like I said, it doesn't in any way bring the victim back, but it does give value to his life to show the community that our community demands a price be paid. So based on all these factors and considering the criteria I've indicated under Code 1925-21, it's going to be the judgment of this court. It should be sentenced to custody of the Idaho Department of Corrections as follows: for a minimum term of 3 years, followed by an indeterminate term of 9 years, for a total of 12 years. In order of fine in this case of $1,000. Standard court costs, payments in the victim's relief fund. Is there restitution, Mr. Neal?
No, I don't believe so.
State's going to allow 30 days for the state to file restitution if there is any in this case. Mr. Neal, the victim witness coordinator, can coordinate the victim's family if there is. The state will allow 30 days for that. I am going to give you credit for any times you've served on this towards that sentence. I will retain jurisdiction as I'm required to do under the plea agreement. Retain jurisdiction for up to 365 days in order to be taken into custody immediately. That rider works is I'll receive a report about a month before you're done. If you've done well, I will have a hearing and consider bringing you back and place you on probation. If you do not do well, I'll relinquish my jurisdiction and you will be required to do the remainder of that sentence, which is indicated, which is up to 12 years. Let me advise you of the right to appeal to the Idaho Supreme Court from this judgment of conviction. You have a right to represent by an attorney in that appeal. You cannot afford one will be appointed to your public expense. However, you only have 42 days from today's date to do that. You also may have rights under Idaho Criminal Rule 35. If you feel the sentence is illegal or unduly harsh, you have 120 days for that. You also have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. Such an action must be filed within 1 year from the date your right to appeal expires. I do want to check one thing. Is there a mandatory driver's license suspension on this case? I don't see it listed in the information, but I wanted to check the statute.
I think the statute requires at least a year, right?
Give me just 1 second. See it in the statute, the court is going to suspend your driver's license for a period of 1 year following a term and condition of if you are placed on probation and the admission of electronic device in that after that year for a period of 2 years. We'll deal, if you are placed on probation, we'll deal with the terms and conditions of that as far as accessing substances at that time. Like I said, you need to understand that if you don't do well, you'll need to do the prison sentence. There is no guarantee that this court will give probation at that point. Okay? Any questions, Mr. Brown?
Just one. Would it be possible for the defendant to have a withheld judgment?
Not at this point. He will have to earn that if and when that becomes applicable in the future. Anything else, Mr. Neal?
Nothing from the state here.
All right, like I said, we've already taken into custody immediately. Other than that, we'll be in recess on this matter. Thank you.
Thanks, Your Honor.